Okay. Okay, let's go.
So
So this is contract law. How many of you had real estate law? Or I mean business law? Okay, so there's very much of basic contract law that is real estate contracts. It's very much the same. You're going to hear about the same kind of things that are involved. The only thing is, instead of dealing with a business issue terminology, we're dealing with real estate. Otherwise, contract law is contract law. Not a lot of difference. Okay, so a contract, what is it? It's an agreement between two or more parties containing certain essential elements. Essential elements that are, what's the business deal they're doing? How will people be compensated? What means it's done? I'm working on a contract today to put $1 million roof on a property. Okay, but it's the contract for the roofing work that I'm working on, not a contract for real estate or anything like that. It's a contract to have the roof put on the building. So it's the contract between us, the property owners, and the contractors that tell us that they're going to get the work done. We expect work done, they get payment when work's done. So the offer is a proposal intended to create a contract on acceptance by the person to whom it's made. We have an offerer, the offeree, specificity that it is for a something they're talking about specifically, and there's communication. What kind of communication do we have in real estate when it pertains to selling and buying, selling real estate? It's in writing. So there's a lot of verbiage. We've talked, we've shown, we've negotiated, but ultimately, anytime we're dealing in real estate, it's going to be in writing. So our communication, a lot of verbal, but it's got to be in writing as well. We can terminate an offer. We can make an offer and we can terminate it by revocation. In other words, I've made an offer, but I want to take it back before it's accepted, so I can revoke it. I can bring it back. I can reject the offer. Okay, I'm making an offer to you as seller to buy your house, but I'm only offering $20,000. The place is worth $100,000. If I'm a decent seller, I'm going to I'll actually reject and respond. Otherwise, I won't even respond. That's my rejection. Lapse of reasonable time. Almost all these contracts we're dealing with in real estate will say that you have to respond within 24 or 48 hours. There's a specific time involved. If that time expires, your contract's no good anymore. It's not an offer anymore. Destruction of the subject matter. Okay, so your condo's destroyed on the island, Lloyd. Okay, but because he's got another place to go to, the whole concept of the timeshare is not destroyed. But let's say he was trying to make an offer on that condo unit to buy it outright, and the hurricane came through. It's destroyed. What's he trying to buy? There isn't anything to buy. There's maybe some sticks and stuff on the property still, but it's not what he anticipated. So it's basically destroyed. The death of the offerer. This is the person making the offer dies. Not the person that's selling, but the person making the offer dies. Why is the death of the offerer going to negate my deal? Well, he's the person of reasonable competence to put the deal together, and he's not available anymore. Death of the seller. Why would that still go on? Because the death of the seller has an estate. So we're buying it from the estate. So it's the death of the offerer that will change things. The insanity of the offerer. They don't have capacity. The legality of the subject matter. We assume that everything we're doing in real estate is legal, but if you're not going to put a legal use in it, there's not a legal intent to start with. What's a legal use? That'll be dictated by zoning. We all know what kind of non-legal uses are, but it's very specific to the zoning laws that are in that area. So you may think it's totally legal. It seems like it's legal, but it can't be there because of the zoning.
I was just going to ask, like, if there's a spouse situation and the husband passes suddenly, the wife, she can't still work with them, but they have to like cancel.
For buying or selling?
For buying.
Yeah, it still would not go through. Well, husband and wife. If she still has capacity, that might not nix the contract. She could still go through it, but she has to have sole capacity on her own to continue on.
Meaning like income.
She'd have to qualify for the loan and everything without him.
Okay.
Yes, yes. So yes, she could step in and take over if he dies or if she dies, and as long as the one still has financial capacity. And sound mind, right? Yeah, after you lose a spouse, you might not be of sound mind. That's a tough one. Acceptance means we want this deal to happen. How do we assent to the terms of an offer? We have manifest intent. Means people are moving along like they intended to happen. Transmittal acceptances, we actually have it in writing. It's real estate. We accept the offer. We not only act like we're going to do, we're taking all the steps to get our financing done and everything we got to do, getting the house ready for the sale and doing things, but we're actually putting something in writing. Revocations. The law deems that an offer impliedly invites acceptance from an offeree by the same mode of communication the offerer used to communicate the offer. Okay. So if we want to revoke the offer, how do we have to revoke the offer? The same method that we delivered the offer. So this dot loop stuff, this is so cool and so great. And dot loop, the best thing about it is that offer can be accepted in minutes. What happened to the chance to revoke your offer? You guys weren't here last night when dot loop presented, but with dot loop today, anything can happen almost instantaneously. You can make an offer on a contract, he can send it to the seller can sign off and send back in a matter of minutes. So, I'm having second thoughts. I don't think I want to offer after all. I'm going to go communicate through the same fashion that I made the offer, but oh no, they already accepted. The revocation's too late in that circumstance. So that's the chance we take with this automatic timing of stuff. An offer may be revoked any time before it is deemed accepted. But again, delivery in the same fashion that the offer was delivered, whether it was through internet, email, we used to say by fax, by courier, in the same fashion. But that's one of the things, as I was sitting there last night, this is an instantaneous world when we're starting to do this stuff these days, and people don't have time to have second thoughts. No buyer remorse. The reality of the assent. There must be reality of assent to an agreement between the parties. In other words, the appearance of assent is not sufficient. So what's our reality in contract terms? We're signing. Everything's in writing. The causes that could intervene to negate a party's assent include fraud. So if somebody's dealing in fraud, somebody accepted and they want to do it, but it's a fraudulent matter, stops not happening. Innocent misrepresentation. It can be a mistake. They can be under duress or undue influence. So when I notarize something, when somebody comes to me, I want to see an ID to make sure they are really who they are, but I ask them, are you doing this of your voluntary will? Is this something you really want to do? I don't have to give them all kinds of formal language. Is this really something you want to do? That to me tells me they're there, not under duress, they really are willing and ready to do it. Consideration. What's consideration? She's back there going like this. Money, money. Is consideration only money? No, consideration can be an act. Can be trading something. It can be good for a good. It can be somebody's services, construction services for getting property. There's all kinds of things that can be considered consideration. We've got to be careful of that. It's a promise, act, or forbearance bargained for and given over in exchange for a promise, act, or forbearance. Most real estate contracts are bilateral, a promise for a promise. So consideration. In a lot of our contracts, when I do a renewal with a tenant, I'm not doing a whole lot of other things, or I would give them expansion or something like that. My consideration, my contract might say for $10 another valuable consideration. We don't actually trade the $10. Used to be $1, by the way. Now we put $10 in there just because the times what they are. But we don't actually trade the money, but we're showing consideration by putting that verbiage in our contract. We're showing that money did change hands. So, promissory estoppel. It's a doctrine that prevents a party from denying that a promise is supported by consideration. You'll read more about it. I'm not going to go on details, but capacity. A legal qualification determines one's ability to enter into a binding contract. Void. Person has no capacity to contract. They're adjudicated insane. This is an issue I have with my brother right now. My mother has Alzheimer's dementia. She's a little over 60 pounds right now. And she's just hanging on. She's been hanging on this way for a long time, but she doesn't have a lot of mental capacity. She's still with my daddy. They've been together 65 years. But if something happens to my dad, my brother's concerned that he has the ability to go in the banking account and take care of my mom. My dad says, absolutely, it's all there, it's all done. The banker looked at my brother a few months ago when he was there, and she's like, it's not done yet. So I said to my brother, you need to get with my dad and make sure all this stuff is taken care of, because my mother does not have capacity. She can't take care of this stuff herself. She doesn't understand this anymore. Voidable, it's a person has limited capacity to enter into a contract. These can be people insane, but it's also minors. This is why we don't like dealing with minors, because as long as a minor is a minor, when they become an age of majority, they can come back and say, the contract's voidable. I'm sorry, I didn't want to do it. I didn't know better. I was too young to be doing this work. So we don't want to deal with minors. We don't lease to minors. We don't do contracts to minors. We will deal with their guardians, but we will not deal with them direct. Drug persons also can be voidable if they're under the influence. It's got to be for a lawful purpose. And in parallel delicto is parties are not at equal fault. I'm not sure, again, where they're coming out with that, but they're trying to point fingers at somebody when this is all going on. Lawful purpose. Does everybody understand what a lawful purpose is? Part of the reason you want to have a realtor involved in commercial transactions, because the realtor doing a commercial transaction does know to look at zoning, knows to look at what can go where. And the layperson may not know all that stuff. Contracts interpreted. The courts interpret language within a contract. If there's conflicts, specific provisions will control over general provisions. So if it's a general and then there's specific provisions under it, I'm having an argument with one of my tenants right now about common area roof charges. The roof is actually excluded from the common area when you read the landlord part of the responsibilities. But when you read common area up in the top of the lease, it says that the landlord can bill for common area costs. My tenants come back and say, oh, no, I'm not paying for that. We're talking the total bill for the tenant is $60. Right now, me and the accountant just want to give them $60 because it's not going to be worth our 3 hours of time going through this back and forth to deal with it. But they have a legitimate beef about the way the contract is worded. So it's a specific provision over the general provision. Handwritten over typewritten. You have a typewritten contract, somebody handwrites on it, the handwriting prevails. Addendum over contract body. You have a primary contract and you have addendums that are added. You will see in the real estate world we deal with addendums for different things to make things happen. The addendum takes precedent over the contract that it's attached to. So remember that flow of things when you're in the real world and you're dealing with business.
We're going to get this back.
Huh?
We're going to get this back.
It's in your textbook.
Oh.
It's all. I'm not doing anything that's not in your textbook. I mean, you guys are breaking your hands right, but I'm not telling you anything that's not in your textbook. You don't need the slides. It's all in your textbook. I'm summarizing what you're going to read. I'm trying to give you real life examples so when you read it, it clicks. It makes sense. Assignment. The present transfer of a property from one person, the assigner, to another, the assignee. Rights to a contract may be transferred to third party unless the contract prohibits the assignment. In my leases, most of my commercial leases say that the property, the lease can be assigned. However, they have to have landlord's written consent. Landlord's written consent will not be unreasonably withheld. Okay, so I've got that in my assignment language. But my assignment language also says that the original guarantor of the lease will never be released. So we go back and say, well, you can assign all you want, but you're never going to get out of the lease. So yeah, you can bring your other business partner in and you can literally walk away and let the other business come in and operate and pay the rent. But if they go bad, we're still coming back after you. So in my mind, that is never a true all the way assignment. An assignment is when somebody can totally step away and never be liable again. So a lot of the contracts prohibit assignment. When I first started in the trust department, I came in that day and my boss was all mad. He just came back from a closing. And he said that the guy just made $10,000. I'm like, what do you mean? What's going on? They went to a closing. They sold to one guy. He sold to somebody else right away. The other people were at the closing, and he made $10,000 right at the closing. I'm like, man, that's real estate. More power to him. He was able to do something and make something happen here. But that was one thing my boss was always on me for years later. Make sure that never happens again. Because he was embarrassed that he thought they were being taken advantage of. I'm like, no. That's not how this works. This is real estate. If you find somebody else that's going to come in, a flipper, to buy, and he flipped it, but he didn't have to come in and do work. He simply found another buyer. And that happens. If you can go in and negotiate for the right price, you can find the next person. And if that was not an assignment, it was just he closed and then he closed to somebody else. Now, if he had tried to assign it, there probably would have been something that said, no, it can't happen. And if that would have happened, the bank would have said, thank you for the extra $10,000.
Well, he took ownership and then
Right, but same closing, didn't even move from the table, just went right to the next one. And that's what really pissed my boss off. Just some kind of investor, but he found somebody else to come in and buy it and make money off it. But just like I said, it really rankled my boss. It's not illegal. Breach of contract. The unexcused failure to perform an obligation under a contract. So we have different ways we breach a contract. Anticipatory breach. It's a breach of a contract that occurs as a result of repudiating a contract before the due date for performance. So before performance even started, they're trying to get out of the contract. Substantial performance, the degree of compliance under the terms of contract that discharges a party from further obligation. Okay, I have an anticipatory type breach that might be happening right now with a restaurant company that's operating a restaurant in one of my shopping centers. And they are about to probably close up. I'm not even sure they'll go to bankruptcy, but they might close. So the anticipatory breach is the fact that they're going to walk away from their lease. Guess what? We're not going to let them walk away from the lease. We're going to go back after them. Substantial performance. They've completed a good portion of their lease, so we can't go back and sue them for what they've already paid rent on, but we can sue them for the remaining rent. So that's how we look at this. What's the remaining? What's been done so far? What's the total obligation?
you have to wait until the lease is up before you go after them.
Oh, no. The minute they walk, they go dark. The minute they go dark, we go after them. This is not the favorite part of my job. Because I got another couple where he's got cancer now and they haven't been paying, and I got to give her a letter. Not the favorite part of my job. Remedies for breach of contract. Specific performance. The court decree mandating a party perform according to contract. Hey, man, you don't want to sell the house, but you signed a contract to say you're going to sell this house to these people. You've had second thoughts. Sorry, you signed the contract. This has gone down the road far enough. The court can mandate specific performance, and they can push the seller out. Rescission. Cancellation of a contract results of the parties being restored to the position they were in before the contract was made. So the courts can come back in and say, man, we just want to make everybody whole. We agree the contract should be done. We just want to make everybody whole at this point in time. So that's what they'll do. Damages. Money recoverable by one suffering a loss or injury due to a breach of the contract. My lease. I'm going to be damaged. They're walking away. They owe me a chunk of money. So I'm going to go back after those monetary damages. Liquidated damages. Amount of money stipulated in contract that will be awarded in the case of a breach, which amounts are reasonably calculated to approximate the actual damages. Okay, so this is liquidated damages, but they're looking at the actual numbers. Okay, paralegal, you need to help me. What is it that people get extra damages when they get hurt in an accident or something happens? It's not liquidated damages, but they get damages. Thank you. Compensatory damages. So liquidated damages is not to be confused with compensatory damages. Compensatory damages is when you say, my feelings were hurt, and now I'm due this amount of money because my feelings were hurt. It's a soft, fuzzy kind of a thing that somebody can help you get. Huh? Can't sleep at night. It happens more than that. I won't even go into where that was just going. But yes, so we can get compensatory damages, but that's not what with our real estate world, we're trying to say this is all because we had stated amounts. So we're going back after the liquidated damages. There's a stated amount to go back after. Foreclosure, a legal process where a non-breaching party can obtain possession of the real property and sell it to recover an amount due. Now, in short sales, people are under the impression that if they do a short sale, they're out from under their mortgage. Is that true?
No, because there's still some left to pay, right?
Right? There's still some left to pay. What happens when you do a short sale? And there is that still some left to pay.
The bank agreed to waive it.
The bank can agree to waive it, and everybody says, oh, good, I don't have to pay it. But guess what happens at the beginning of next year? You're going to get a 1099 that says the bank just gave you that much money in compensation. So you still have to pay taxes on it.
I thought there's a law though that excuses that money for tax purposes when there is a short sale.
Not that I'm aware of. There might be.
Yeah,
But that was the confusion. A lot of people thought they were having short sales. Oh, the bank is going to let us walk away. But you owe taxes on that. That was compensation. The bank has to declare, they're going to declare a loss on their books, but they're going to give you a nice little 1099 at the end of the year. Or the bank cannot let you be whole. The bank can force the short sale, sell, let somebody else move in, and they can come back and try to collect the rest of the money from you. They can do lawsuit. Foreclosure is the same kind of thing. The bank might not be made. For the most part, though, when a foreclosure happens, it's done. The bank is settling. They kick you out. They're settling for whatever they can get for the resale. That's not the same as a short sale. Short sale, people are kind of taking their chances. I know realtors that will not deal. They will not help somebody buy or sell a short sale because of how involved it is. The banks can have things going on for 6 to 9 months. People qualify for mortgage, then they're no longer qualified. They got to come back and requalify. The bank can keep taking bids while they're going through the short sale process, and all of a sudden somebody stepped in willing to pay the bank more, and you're out. So it messes with people a whole lot. So I know a lot of realtors that when we go to ethics classes, that's the biggest thing that people discuss all the time. I sit in the back of the class and go, good, I'm not doing residential real estate. But they're talking about all these things that happen with short sales, and they don't want to do them.
Specific performance, the seller, like, say to give a month, they are pending a month to buy a house. And then the seller really, they sign the contract, it's gone too long, but can the buyer back out the last minute, or are they in a specific performance to that actually have the buyer?
It depends upon the contract. It wasn't revoked. The contract's going on. Everybody's working like the contract's going on. The buyer may have to buy. They may have to, that's where the seller goes to the court and says, man, I wanted to sell. I was done with the house. The courts may force the buyer to buy. If he still qualifies, still gets his financing, and still can make a ready, willing, and able buyer, the courts can force that. That definitely is specific performance, making it happen. Discharge, the release of contractual obligations by operations of the parties. You can do it through novation, where somebody can kind of step in. You can do it through accord, and you can do it through satisfaction. So we're getting rid of the contractual obligation. We're discharging it. We're calling it done. The operation of law, circumstances may occur that make it impossible in practice for party to fulfill obligations under a contract. So the operation of law can come in and say, it can't be done. Okay, the party's not, the property's gone. There was eminent domain. Something else happened that they can't physically perform anymore. They can use the courts to help them stop that. If this happens, the law will excuse the party from performance. So the specific performance gets canceled because it can't happen. But they don't get it, so they go to court. They push until they get a court order. Okay, that's it for chapter 10. It's clear as mud. Okay, so